both the panelists. And first time up till now, we have done several programs, but this program we extended to second week, and that shows the interest of the all participants. And as I was discussing with Mr. Bala earlier, that there was many compliments received that they enjoyed the session because of this informal discussion. Because first time I developed so much of discussion and we spent so much time on discussion. I was also concerned at the end many were leaving. So I thought that whether they are liking or not liking, we can't make it. But mixed reaction for participants. I think the one whose questions were answered, they left, and but many has appreciated. So we will keep on that only. And I think now I don't need introduction, but just for the people who was not there last week, Mr. Sanjay is since long, Mr. Sanjay and Mr. Umesh Ved is today's our panelist, and of course our Mr. Bala is there. Mr. Sanjay is company secretary and law graduate and having overall business management exposure experience of 30 years of post qualification, and having blend of industry and practice. He had varied exposure in the field of corporate law, including FDI, finance, project management, and management and administration. Mr. Umesh Ved, a practicing CS from Ahmedabad, is having post-qualification experience of more than 2 decades. He is also graduate in law and insolvency practitioner. He is practicing in the area specialized in merger amalgamation, IBC security law, FEMA, and is providing services and also appearing before the court judicial body. Welcome, Mr. Sanjay and Mr. Umesh Ved. They both will join. Mr. Umesh will join in 5-10 minutes. Meanwhile, we are starting the. Thanks.
Thank you for giving this opportunity.
Thank you. It's our pleasure. And our Mr. Bala is our own is there. Sailesh is there. I welcome all. And let's start the session. And what we can do, we will take the questions after Umesh Bhai join. What is unanswered?
Yeah, we can start with the presentation.
Yeah.
Once Umesh ji.
Yeah. And then we will take that unanswered question once Umesh Bhai join. Okay. 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 Our own presenter are Ms. Khushi Jain and Mr. Sumit Bhave. Now I'll request them both to start the presentation, please. Thank you.
Hello. Good morning, everyone.
Good morning.
Myself Sumit Bhave, CS Management Trainee at Mehta & Mehta, here for presentation on directors. I also have Ms. Khushi Jain with me for the presentation. So as you all know, due to last week, due to time constraint, we were not able to complete the presentation. So I would like to start from where we stopped previously. Before going further to previous section, let's talk about what we discussed in previous section. So I would like to start where we discussed regarding the director, naming of directors, board of directors.
Sumit, will you please speak into the mic? You are not very clearly audible.
Hello, I'm audible, sir, now?
That's right.
Yeah.
That's right. That's right.
Okay, sir. So in this, we discuss about the types of directors. So we discuss in brief about all the types of directors which in the board which need to be appointed. So in next slide, we discuss regarding the different types of directors in brief. First, we discuss about the independent director, women director, and then regarding the statistics of women director in India as well as in overseas countries. Next, we talked about regarding the independent directors, his applicability, and all those things. So moving further, we talked about the directors and all the types of other directors like resident directors, nominee director, additional director. So I would like to start the presentation from the next slide, which is regarding alternate director. So alternate director is one who is appointed on behalf of the director who is out of India for a period of more than 3 months. He is appointed as a substitute of the director who is out of India. If the director who is outside India is an independent director, then such alternate director should also be an independent director. His independence should be dependent on the director who is outside India. Moving forward to the next type of director is small shareholder director. Before going to the small shareholder director, let's see first what is meant by small shareholder. So shareholders who hold shares of nominal value of less than 20,000 is called a small shareholder. So as we all know, that company being an artificial legal person is dependent on the decision of the shareholder. So being a shareholder holding less percentage of shares in company do not get the much right to represent himself on the board towards the decision making of the company. Due to which the small shareholder director is appointed on the board as a representative of the small shareholder director. Moving further to the next slide. Now let's talk about the types of director.
1 minute, take to that slide,
Yes, yes.
previous slide. In this alternate director, generally there is a practice, there is a tendency, the director who is moving out of India or remaining absent, they recommend the director name that please appoint him as my alternate director.
Yes.
Whether board is bound to appoint that person as a director, as alternate director.
So if the director which is outside India is independent director, then such person, the person who is appointed as the independent alternate director should be independent. As also the board need to consider the relevant expertise of the director who is appointed as an alternate director. So it depends on the board to be up to appoint himself as alternate director or not.
Panel, your view?
The alternate director who is recommended by the director can be appointed as alternate director, but is subject to he fulfills the conditions of the various appointment conditions for the director. That should be the case.
Normally, it is the right of
Yeah.
the director to propose name of the alternate director. For any reason, if the board feels that that person is not suitable to the stature of the entire board, they may request the original director to propose any other person's name which should be acceptable. Otherwise, board should accept the appointment of nomination of the alternate director.
Yeah, because alternate director is a person who's appointed on behalf of the director who wants to appoint him alternate director. So that is more or less, is right. So board otherwise feels that person is not suitable to fulfill the conditions of etc. and other things and all. If they have the reservation, then as Mr. Sanjay suggested, they will say, okay, look here, this is the problem, you suggest somebody else. Otherwise, normally they won't accept.
Okay, thanks. Second question, if a woman director is remaining absent for long period, whether alternate director should be woman director?
According to me, the answer should be yes, because being specific, as we can see that in the case of independent director, the independency of the person does matters. Like the same in case of woman director, the reason for appointing a woman in the board should be considerable appointing alternate director on the behalf of the woman director.
Panel, your view? Thanks.
There are two things here. Only the companies in which a women director is required to be there, where the classified companies. In such a cases, I think woman director should be alternate director, the woman director. But the other companies where the woman director is not a compulsory one, if the woman director is there, she will be able to appoint anybody else to represent her because it's only on behalf of her representation in the board. Because in the classified companies where the woman director is required, then in which case that condition will go.
Mr. Sanjay, your view?
Sorry, I was on a call in between. Can you repeat the query, Dipti?
It was, I questioned that if a woman director is going out of country for 3 months or that absence, whether alternate director should be woman director?
As per not necessary, because what is required is composition. Woman director is required in the composition, and by appointment of an alternate director, that woman director is not leaving the composition of the board. So, for a woman director, there can be anyone else also be the. I mean, a male person can also be an alternate director.
But in that
Because it
case,
is not affecting the composition of the board. your composition of board continues to have a woman director.
Okay, but in that case, independent director, why we are insisting independent director? Alternate.
Sorry?
Director. If the independent director is absent, then we appoint alternate director. We appoint only the person who is independent.
That is necessary because in case of an independent director, if you are appointing a person who is part of the promoter group or who is in employment of the company, the status of independence is lost, which is the basic core criteria of independent director.
Right. Okay, I think, yeah, there is a no statutory provision, but if even I believe, so far possible, if woman director is going an alternate director to be appointed, it should be preferably woman, that the purpose, that spirit of the law is served.
Yeah, you are right. Absolutely. There is no mandatory requirement. Woman
Ah.
director need to appoint a woman director like independent director. Mandatorily, there is no provision. But in my view, in the better corporate governance, the companies where woman director representation, it is not only the composition, it is also a representation should be there in the board. In which case, ideally, the woman director in the companies where the woman director requirement composition makes it compulsory, it is preferable to have a woman director appointed as alternate director. That is my view.
There is a question in chat box. Can alternate director be appointed for independent director also? Presenter, you can answer this. You are just now telling this. Hello?
I think he is not able to hear. His mic is muted, I think.
Sumit.
Yes,
Sumit,
ma'am. Yes, ma'am. Yes, ma'am.
you can answer this. Can alternate director be appointed for independent director also?
We can say that alternate director is responsible is appointed only in case where the other director is outside India for more than 3 months.
Yeah. That is there. But whether you can appoint, if independent director is out for more than 3 months, you can appoint alternate director in place of this independent director.
Yes, ma'am. But the alternate director should be independent in this case.
Yeah. Okay. Chalo.
Dipti, just a minute. I think Sanjay has raised a very, very important point. What Sanjay is saying, and correct me if I'm wrong, Sanjay, that a person who appoints an alternate director, therefore the original director, he continues to be counted either as, or she continues to be counted either as a woman director or as an independent director. Does she continue to be counted? It's a very important point you have made, Sanjay.
Yeah, no, in fact, I just wanted to highlight one more important aspect here. In light of this current scenario of virtual meetings, there
Yes.
can be a scenario possible that alternate director as well as original director both are attending the meeting. And still we are in compliance with the requirement of the Act.
No, then the alternate director is not counted, no?
No, so for voting purpose, alternate director would not be counted, but we cannot take away the right of the alternate director to attend and participate in the meeting.
In the past, we used to have, I don't know whether it still exists, that when that original director comes into the state, this man's position ceases. I think that is gone now.
No. That position is still there. Now it is.
Then you have to look at it like that. That if he comes on.
No, here because he is attending meeting virtually, he can attend even from outside India. So the meeting attendance, for the purpose of the meeting attendance, original director would be available, and in that case, the alternate director's role would be only to participate in the meeting discussion. He cannot participate for any decision making process because because the original director is available, he would be participating. This type of a situation can come across in any of the company. Incidentally, we faced this situation in one of our company.
Sanjay, no, I was referring to a different point which you made and which is a very important point.
Right.
See, suppose it's a woman director who appoints an alternate director. As a result of this, and the other one appointed is a male. All right. As a result of this, the required ratio is not fulfilled. I think what you said was that still it is fulfilled because that woman director, original woman director continues to be on the board.
Very correct.
This is a very important point. I was not aware of this.
Sailesh bhai, we are not talking that ratio is getting impaired. It is there. Their appointment continues. So your composition per se is not non-compliance. We are not talking that way. But the same way, like independent director is like you ensure that only independent director participate in the actual decision making. Same
Yes.
way, when you are appointing woman director with the purpose that there should be gender,
Yes.
equalizer.
Correct. Yeah.
Same, why not in actual decision making even that time? That was our point.
So therefore, if an alternate person is appointed and that alternate is a male, then the requirement is not fulfilled.
It's, since it is not statutorily required, it can be. But as a governance, we were talking. Statutory, it is not.
What about validity of meetings? If no woman director is available in a meeting, present in a meeting, the meeting is still valid, isn't it?
Yeah.
Yes, it is still valid.
Yeah, it is still valid.
Then that point will take.
Yeah.
Yeah, continue.
And just last sentence. Whatever participation the alternate director is doing, alternate director actually is doing on behalf of the original director.
Right?
Yes, that is true.
Actually, it is his duty to take the direction from the original director.
Very correct.
What is his view, and that only he should come. He's a communicator and representative. Actually, representative means he represent and give the views of the original director.
But the gender sensitivity cannot come in through this.
Proxy with limited rights.
Okay.
Gender sensitivity is lost. Okay.
Yeah, this point, Sanjay, is that both original and alternate director attend was interesting. That you cannot say no.
Yeah, no, incidentally, we faced this situation in one of the meeting at our end during this pandemic era.
Yeah, I think they should come out with a clarification now, since video meeting and all this is allowed.
Yeah. In
They
case
should
of
say
the
that, if you are conducting this and this person can attend, then the requirement of this is not there.
By way of good corporate governance, in such a case, the alternate director should recuse himself.
Let's see. Okay.
Yes.
in
Please
fact,
continue.
there was an interesting case. So there some years back in Bombay High Court. In one of the companies, what has happened is the alternate director who was actually appointed, he actually went for a short period for a Christmas holiday. Somewhere on 28th or something like that, he went for a Christmas holiday. And he went out for a holiday and he returned back to India to celebrate his New Year. He returned back on 30th of December. He celebrated the New Year on 31st. He left actually on 1st of January back to his holidays. Now what happened? The company seemed to have filed that time director DR12 form saying that the alternate ceases to be a director because he has returned back to the original state. But subsequently, when the meeting was come, the alternate director challenged that he still continued to be alternate director. The matter came up to the Bombay High Court. Bombay High Court has delivered a judgment saying that the returning the original state of the state is not only enough, making him not possible to attend the meeting is really required. If he is actually returned back for the short while and he is not available for attending the meeting, but still he continued to be alternate director. That sort of a judgment has come some time back, some years back in Bombay High Court.
Yeah, interesting. Thank you. Thank you for inputs, Mr. Bala. Yes, ma'am. Continue.
So has now we talked about the type.
Yeah.
Ma'am, Alifia here.
Yeah.
I want to ask one query pertaining to alternate director.
Yeah.
One of our clients wants to appoint an alternate director for its foreign directors. So can that be done? And even the alternate director who is getting appointed is not resident in India.
Yeah, it can be.
Possible.
Yeah.
It
So
is
even-
possible.
Even for a
foreign
foreign,
director can always appoint alternate director. There is no question arises.
But even if the alternate director is not in India,
बाहर प्रिंट आया देखो, 2 प्रिंट आया होगा.
because
That's not a
once
problem as long as that alternate director is willing to come to India to participate in the
The
meeting.
board meetings, correct.
because section 161(2) states that during the absence of the director from India, so when the original director is absent from India for a period of 3 months or more, here the director is not in India only from the start.
That doesn't make any difference, Alifia. See, this is a choice of the alternate original director to whom he wants to appoint, and as long as the board is okay with that particular choice, the person can be a resident or non-resident, as and that person would have then right to come to India and participate in the meeting or come to the location. In fact, the meeting could be at outside India as well. So if the as long as he is participating in the meeting physically, wherever the meeting venue is, he is okay. He can join the meet. He is okay, and his appointment is okay.
No, what he is
There
asking,
is there
Sanjay,
is no restriction on appointment of a non-resident who is not in India at the time of appointment
no,
under
no,
the
no.
statute.
Sanjay, his question is the original director is foreign national only.
Correct. And
And
he
now
is appointing another foreign national as the director.
no, that is
That's
Indian or foreign is not there. Her question is, this is a director out of India for more than 3 months. This
huh.
director, original director is not in India at all. So whether he can appoint alternate, that is the
He
question.
can. He can.
Yeah.
Not that, but Dipti ma'am, good morning.
Welcome, Umesh bhai.
Sanjay bhai, good morning.
Good morning.
My view is that view of now these all circulars into this COVID time, does this alternate director
So we just
really
discussed.
matters? Because now it is a virtual meeting which are being conducted, whether is in India or not India. The only thing I don't know the requirement with regard to attending at least one meeting, that also it can be done virtually. Whether it really matters whether the director is in India or not. Probably the law framer should take a note of it and amend that particular provisions wherein which says that the director, if he is outside India for more than 3 months, he has to appoint an alternate director.
Umesh bhai, we just now discussed the same thing before you joined. That
Yeah.
I was just
So sorry,
explaining.
so sorry, so
No, no, no,
sorry.
it's okay.
No, the same point was actually discussed probably in the light of, virtual board meeting, etc. This is no longer is going to be a point.
Okay,
And probably the
question.
law will get amended in the course of time.
Panelist question started. Okay. Unanswered, but now this also started. Unanswered will take at last. All the participants last week unanswered questions will take last now to keep a track. Now the first question, chairman of a company is non-executive foreign director and always attend board meeting via VC. Now query is chairman should preside over meeting who is attending from remote area. Or we can elect one of the director present at venue as chairman of the meeting. Kindly guide with reference to any relevant section as secretary started.
So basically, the person who is chairing the meeting, there is no such requirement that he should be at the venue of the meeting. As long as he can effectively chair the meeting proceedings from the location where he is, the chairman can continue to operate virtually as well.
Sanjay, to add that one question, that where the meeting will be held in virtual meeting can be said, because you have to mention where the meeting will happen.
Yeah, so there are two situations of the venue. One is where the chairperson is there, or else where is the company secretary and most of the directors are present. So
So you
there
can,
can be a situation that all directors and company secretary is present in the boardroom and chairman is attending meeting virtually.
and if everyone attending virtually then?
No, so if everyone is attending virtually, then there is no issue. I believe the question is if chairman is attending virtually, whether we need to appoint anybody who is present if in physical to be the chairperson. Am I right?
Yeah,
It's
yeah.
the querist.
Yeah. Next question, two directors, husband and wife of a private company and the only shareholder of this company. decided to propose alteration of article by inserting article of proxy appointed by individual shareholders shall be counted for the purpose of quorum at all general meeting. This amendment was proposed in terms of notification of 5th June 15 issued by NCA, giving certain exemptions to private companies and to comply holding AGM on time when they are outside India. The exemption provided is section 103 quorum shall apply unless otherwise specified in respective section or the articles of the company provide otherwise. Will this proposal by board be tenable in law?
Dipti, is it possible to put this query on the screen?
It's on the screen only, chat box you open.
Chat box.
Go down,
Is
go
not
down.
there into the.
No, go down
It is-
earlier. Listen. On the top, he has pasted last week's, but you scroll down, you will get it. 11:21.
Diptiban, probably the queryist has sent only. Diptiban, it may happen that he or she has not sent to everyone, because in the chat there are only two queries, one from Vandana Patel and one from Virendra Verma. There is no other query in the chat box, so probably he or she must have sent the chat to you only. So you may copy it and paste it for everyone, then we can see it.
I already instructed my IT team is checking. Meanwhile, I'll just brief the question that there are in private company 2 directors. They are only shareholders. AGM, they are going out of country. AGM has to be conducted. So what they are doing, they are introducing a resolution whereby individual appointing proxy is allowed to have a right in the voting in the general meeting. They are referring the notification of 5th June 15, whereby exemption is provided. Also, they have referred the section 103 where exemption to private company. That quorum will be unless specifically apply, all the provisions of the act will be applicable. Now, question is whether this will be valid. Mr. Shiv Kumar, you want to count the quorum and when these 2 people will be out, right? That is your question by proxy.
Yeah, yes.
Umesh Bhai and Sanjay Bhai, the question is that since there are 2 directors, 2 shareholders, they are going out of country. AGM to be held in India. They want the comply. So they want that they will give proxy, amend the article that proxy is allowed as a quorum. Whether this resolution is valid.
Feel that it is not valid because it is going against the provision of the act that minimum 2 directors, minimum 2 members in person should be present for the annual general meeting.
Now he is telling that that section, even though quorum 103 is there, but quorum of 2%, meeting will happen only if 2 people are there.
Hello.
Any other view? Sorry, yeah.
Can I interrupt?
Yeah.
Yeah, please.
Yeah. See, if you see the exemptions, it says that unless the articles provide otherwise, then it should be 2 persons personally present. So is it not a privilege given to a private company that they can have their own articles and say either 1 person or 2 person can be a proxy to comply the provisions? Is it not that the interpretation? Because the notification itself says that you can have it in your articles and then accordingly comply. So is it not the correct interpretation? That is what my doubt was.
But if it doesn't have that provision, then you have to amend the articles.
Yeah, we have
already amended the
And
article.
again, to amend the articles, you need to hold an AGM.
Yeah,
Sorry,
that and all
GM.
will do. That and all will be done.
How will you do it? Those 2 persons are not there.
No, they are there and they are passing the resolution whereby proxy is counted as a quorum in private company.
No, so
Correct.
I was just looking at 103 for this purpose. Now, what Shiv Kumar is saying that can be done by a private company. And with regard to the Sailej's observation, that can also be done. They can first create an EGM outside India, because EGM can be outside India where they can pass a resolution to amend articles, and thereby enabling the appointment of proxy for the purpose of attending the general meeting, and then annual general meeting can be held in India.
So it is possible.
It is possible.
Yes.
First amend the articles, and for amending articles,
Yeah,
hold an
yeah, yeah,
EGM, and EGM need not be held only at the place of the register.
Very good question, Mr. Shiv
Very
Kumar.
good answer. Lovely, lovely, Sanjay. Very nice.
Deepti-ben, Jugaad-wado answer can be that transfer 10 shares to the employees of the company, let them conduct the AGM and complete the issue. Why to file so much of forms? Once they return back, that 10 shares once again can be retransferred. That is the practical solution.
Yes.
That is what
Then
many
why
companies
why
are
to do
actually
10
doing.
shares? Even one share is good enough.
That is
That
what
is-
many companies are actually doing it.
Hello.
Yeah.
Yeah, sir.
But it-
Why unnecessarily to amend? See, it is costing more unless and until you feel very, very uncomfortable or it is a very, very serious issue. But this is a better solution. Anyway, go ahead, Pritiman. This is only the practical solution, which I would have said to them instead of filing so much of forms, and but because that articles would be permanently required to be amended, it is permanently required to be wheresoever it is to be circulated. You have to keep a check and control whether it is an amended one or not amended one. That creates a lot of confusions in future.
Okay.
Please go ahead, Pritiben.
Board of Private Company passed a resolution providing its immovable property to secure loan obtained by another private company. Means a company has provided collateral security for loan obtained by another private company, group company. Bank refused to accept this security by saying that memorandum of the private company does not have clause of providing third party security or guarantee, and the transaction rendered to be ultra vires. The director said that they have exercised power under section 179. Are they correct in the stand taken? So whether to provide a collateral security to third company, there should be the provision in memorandum article object clause. That is the question.
That has to be, Diptiben. There has to be, because bankers at times, they have argued that you don't have the power to provide a corporate guarantee, and to provide a corporate guarantee, specific power is required by the board to provide a corporate guarantee. At times, bankers, I have also faced these issues in the past wherein the memorandum was required to be altered for satisfaction of the bankers.
So, but it is as per the Companies Act requirement they are telling, because, or it is because bankers, we agree, bankers say we have to do that.
These are all inherent powers of the board of directors, but probably say but the guarantee etc. Falls under section 185, 181,
186.
186. Now say to provide a guarantee or to provide a loan or to do an investments. Now, if does not have the power, see, formerly into the memorandum, we had main object, incidental objects, and other objects. Now there are only main objects and other objects which are required for compliance of main object. So into that scenario, whether the directors can provide a guarantee, whether because their main business is to do textile or a steel company or a manufacturing company, engineering company, whatsoever it is. But it is none of the business to provide the corporate guarantee on behalf of the third person to a fourth person. So it may require the clause, but there is no specific, I don't recollect having any specific provisions, but logic says that it has to be there, the power has to be there. And how can it be exercised and how far it is, necessary? If you see the division of Memorandum of Association, how far it is necessary to attain the main object. If I am into a textile manufacturing company, how does providing corporate guarantee help me into achieving my this thing? The textile object clause. So it is required according to me. I would go with, say, like to know the views of Sanjay Bhai and Rama sir,
So,
Balakrishnan sir.
sir, basically the guarantee to be given by a company, when company is giving a guarantee for its own performance, that would not be treated as a guarantee. That is a performance guarantee, and that is not covered
That
under
is a
section
different thing. That is
186.
a different thing.
Right, right. No, I'm just differentiating between the two, nothing
Yeah,
else.
yeah, yeah.
When company is giving guarantee for loan performance of someone else, whether it is a subsidiary entity, related entity or unrelated entity, that would be for a third party in all possible manner. I mean, in all the cases, the guarantee would be given for a third party only, and that can be given either to the bank of that third party or to the other contractors engaging with that particular third party. So guarantee would always be for a third party, and 186 very specifically provides when a guarantee is to be given, that need to be given subject to the authority given by the shareholders within the specific limit, and above the specific limit, and if it is within the specific limit, it should be by a virtue of a board resolution. Now coming to the memorandum of association, there should be a specific authority available in the object clause that the company can issue a guarantee. If this is not there, the all authorities given by shareholders resolution or board resolution would be infructuous.
Okay.
Absolutely, you are correct, Sanjay. Because when they refer the section 179, 179 section gives all the powers to the board of directors to carry out all the acts in order to achieve, as Umesh puts it correctly, in the company's main objectives and achieves. For that purpose, it gives the whole power. But anything which is other than that, like third party guarantee, it will definitely call for authority specifically given in the memorandum.
And Umesh bhai, just to answer to your specific observation of whether any issuance of guarantee would be in furtherance of the objects of the company, if as a textile manufacturer, if I am giving guarantee to acquire yarn from the third party, that is in furtherance of my particular objective.
That is the furtherance of our own object.
Yeah, but in case if I am giving it for buying of share by that particular third party, possibly the answer would be negative. So that depends on each individual
Negative,
situation.
exactly.
Right.
Yeah.
Okay. Mr. Sivkumar has raised the question, but it is not relevant to at present for topic, so we'll move ahead. Sumit, you can start, continue your presentation.
Okay, ma'am.
Sivkumar will take your question later. Thanks.
So as we all talked about the types of directors now let's see how director is appointed. So for the same, first step is to convene a board meeting, having agenda for appointment of additional director.
9.
So as we already discussed that what additional director is, being a person who is proposed to be appointed as a director.
So you were talking on small director and you were, and in between we jumped. So I think small director is left, Sumit.
Acha, okay.
No, he has covered small director as well.
Okay.
We started the queries after that.
Okay. Carry on. Sorry.
Okay, so as we all discussed about the additional director, being a person who is proposed to be appointed as a director must ensure that he must have a dean. So the director must have a valid dean before proposing to be appointed as a director. A director can make an application for a dean by filing e-form DR3 with MC. Once a board passes a resolution for appointment of the director, then the company need to file e-form DR12 within 30 days from the passing of the resolution. Also, the board needs to ask for a declaration from the director stating that he is not disqualified to be appointed as a director. Also, while uploading form DR12, it is also required to attach DR2, DR8, MBPU, and CTC of the resolution which was passed in the board meeting.
Are you
Now,
required to attach MBP1 also to the DI12?
yes, sir.
MBP1 is not required.
It's not required, but it's as a good corporate governance we attach.
It is not a mandatory requirement.
Yes, sir.
Sumit, Sumit, in one of my interaction with a very, very senior counsel, he said that when someone is asking your name, don't give your father's name. So, so basically, my advice would be not to give any information which is not required, because we don't know where and how it can be used or misused.
Yes, sir.
So
Right.
whatsoever the compulsion, we give our name only and not our father's name. So this
Yeah,
is
well,
my view.
actually, I would support Umesh Bhai's view. When you are submitting any of the documents to the government, you should be to the point and not give some extra information.
Okay, sir.
Unless and until that information is going to help you in some manner. Maybe when you are submitting an application and you want to give some additional point which may favor your application, that is good enough. But when submitting returns, documents, information, that should be to the point.
Okay, sir.
Yeah. Go ahead. Sid.
So now moving forward, let's see how managing director is appointed. So as we discussed in our previous slide regarding appointment of director, just
Your
like the same.
voice, Sumit, take the mic properly. Your voice is cracking.
Oh, am I audible now, rightly, ma'am?
Yeah.
So just like the same, managing director is appointed. Firstly, additional director is appointed by the board, and after the same, shareholder passes a resolution for change of designation from additional director to managing director. There's one more step which need to be followed, is filing e-form MR1, which is particular for appointment of managing director. So that's the normal procedure for appointment of managing director. Also, filing of form MR1 is not required if a private company is appointing a managing director. That's the exemption given to the private company. So now moving forward to the next slide, which is about the powers of the board. So the provision of the powers of the board is being mentioned under section 179 of the Companies Act 2013. There are various powers which are given to the board in that section. They are as follows: power to make calls from the shareholder for unpaid value of shares, power to authorize the buyback of the shares which are issued by the company. However, board only have authority to buy back the shares up to certain percentage. If the board wants to do buyback exceeding such percentage, then board needs to take prior approval of the shareholders of the company by passing the resolution in the general meeting. Next power is regarding power to borrow monies. As we all know that for smooth functioning of the company, adequate liquidity is required. So as when if the board is required for cash, the board has power to borrow monies from the meeting for meeting their day-to-day business operations. Next is issuing the securities and raising the fund. The company have two sources of for raising the funds. One is internal source and second is external source. So as we all know that board is also authorized to issue securities and raise from the meeting. Next power is regarding power to approve the financials of the company. So
Manali Tushi, can you please mute your mic?
hello, can I start?
Yeah, please go ahead.
So the next power is regarding the power to approve the financials of the company. So I would like to add a comment regarding the same. If the private company there are two directors, the mandatory requirement is minimum two directors. So the director is responsible to sign the financials of the company. So how can it be termed as the power of the board? I think it should be a duty. What is your comment regarding the same? Hello.
Sumit, if I understood your query rightly, you are saying that power to sign is the duty rather than the power available to them.
Yes, sir.
Okay. And you are specifically referring to the private limited company
Yes,
where
sir.
directors are there.
Yes.
Now, there are two different things. One is the authentication and one is the approval. Authentication is putting the signature, which is
Yes.
not the power of the board. That's a duty of the director.
Yes.
Once it is approved by the board, and approved by board would constitute the entire board and not an individual director, whereas signature would be done by an individual director. That's the difference I would look at. I would also look for observation from other panel members.
Umesh bhai,
Yeah.
your comment?
No, I would like to say, give after Bala Sahib give because I was not very much attentive. A query, what is the query, Sumit? Can you please repeat it for me?
It's like in private company, minimum directors need to be appointed are 2 directors, and they are wholly responsible to sign the financials of the company. So how can it be termed as the power of the company? It should be duty according to what I would say, because there is no other director
See,
who can sign the.
but it is rather the duty power to borrow monies or power to authorize. But see, all the powers are inherent duties when a director is appointed.
Yes, sir.
And they assume this responsibility since they are into the management. They are given the rights to run the affairs of the company. And these are the only thing is that this has not envisaged only 2 directors. While framing the law, the vision of the law framers remains that it is a widely held company. So if a single individual does this, that is an authority. But to give and root through the board meeting, basically it is an intention that it is the largely all are involved, say 10, 12, 5, 7, whatsoever the number of directors are there. It is that it has the concurrence of the entire board who are into the management to run and have the control of the company, and it cannot be exercised by a single director. Basically, that is the dissemination of informations and getting a common view and say the inputs from one and all directors. Basically, that is what it says.
According to me, his question is that giving the information, right and correct information, getting audited, give the comments on that, give report on that. Do you think it's a right of board or it is the duty of the board?
Yes, sir. Right.
It is
That's
the
what I want to
duty.
ask.
It is the duty, Diptiben, which is attached to the position.
But it is mentioned in the power of the board.
No, no, no.
In the
One
company
minute.
secretary.
Dipti,
I
I
would
believe
say-
we are
Diptiben,
mixing up two
it
points.
is, you are going very Sumit. It is very see what your balka वो balka खाल निकाल रहे हैं. Basically, it is the
आगे जाते हैं, चलो.
basically the intention of law framers must be that if you see the objects and vision, objects and reasons for enactment, then what it says is that this power has to the decision to borrow, the decision to lend, or decision to diversify, decision to give grant loans, etc., etc. The entire board of directors should be taken into confidence. It should be in consonance. See,
What is
though
the
it is
matter?
given into the powers, it remains the duties, because had there
Okay.
been powers
चलो
for
खाल नहीं
not
उखाड़ते हैं.
exercising,
खाल नहीं उखाड़ते हैं.
for not exercising the powers, ROC would not have prosecuted the directors. So it is the duty which has not, hence there are show cause notices from later. So basically it is a duty. They have failed to confirm their duties or to perform their duties properly, and that is why the regulator sends notices. So though it is given into power, it's that these powers are to be exercised only at the board meeting. Except board meeting, these powers can't be exercised by the individual.
Okay.
Yes, sir.
Sumit, next.
Okay. So moving forward, so company being an artificial legal person cannot approve. So this is wrong. We have covered this topic in upcoming slide also regarding the signing of the financials and all those things. So the next power is which is company has power to grant loan or give guarantee. This power can be exercised by the board when the board is having excess cash inflow, and such cash is currently not in use. So to earn extra revenue from such cash lying, the board can then grant a loan and earn interest on such transactions. This will increase the revenue of the company. The next power is to diversify the business of the company. Like Reliance, ITC, all such big sharks are perfectly example of the diversification of the business. As we all know that the growth diversification is must, and for the same, the board has power to diversify the business and enter into different business lines. The next power is to invest the funds of the company. So as we all are aware about the value of investing in our life, like the same, the company also invests in different kinds of companies. Moving forward to the yes, sir.
But this power to grant loans, give security, and the power to invest, should we not say immediately in that, but subject to the provisions of 186?
Yes, sir.
At least it is subject to 186.
Yes.
I think in a presentation, one should say that, though it is not mentioned in law.
Yes, sir.
Because it has got to be okay under
Yeah,
186.
next.
Yeah, okay.
The law covers it in section 186 that all these powers beyond the limit need shareholders approval.
True, but in a presentation quickly one could
Yeah,
always write.
obviously, that's correct.
Yeah, okay.
Moving forward to the next slide, the board also has power to approve the amalgamation mergers of the company. As we all know, that directors know in and out of the companies, and they're well aware of such situations where the amalgamation or merger of two companies will lead to better and efficient growth of the company. Hence, to achieve such growth and to become a market leader, the board has a power to amalgamate and merge. Like the same, the next power is also same, where the board can also take over or acquire the control of another company. All these are the powers of the board of directors. Moving to the next slide.
Okay, Sumit.
Yes, ma'am.
Just 1 minute. Mr. Rathi, you are available 5 minutes. I'll take the question. Or you are leaving.
Yeah, I am available for 5 minutes.
Okay. The question is it possible to appoint? Is it possible to appoint a director at a board meeting today, which is effective future date? And what if the shareholders meeting of the company is before the effective date of appointment, say October, and the appointment is made effective December? Will the director be appointed as an additional director or just a director at the board meeting? Panel.
You are saying that in today's meeting, you are appointing a person as a additional director with effect from
December.
December 1st, December 2022.
And before that, there is
Before
a
that, in the AGM, his appointment is regularized.
I don't know that they are not. Oshin Dekosa, can you unmute and raise the query, please?
Hello, am I audible?
Yeah, please get.
Yeah, so what if we appoint a director at the board meeting today, but his effective date is much later on, like not before the shareholders meeting?
Yeah.
So is this person going to be appointed like as an additional director, or is he just a director at today's board meeting?
As per me, because you have once again appointed that person as a director in the annual general meeting or the general meeting, he would be directly appointed as a director and not as an additional director. And board should take note of that particular appointment in the subsequent meeting of the annual general meeting and ratify their earlier resolution as a good governance practice.
Okay, thank you.
I think the question of appointing him as additional director doesn't arise until for December. So if he is appointed at the general meeting as a director, that's a different matter. Then he's appointed as a director as Sanjay just said just now.
Perfectly right. And
but if there is no specific resolution appointing him as a director, rather than converting him from additional director to regular director, then on the date of the general meeting is nothing. You have to wait till 3rd December.
Mr. Dilip is raised last week this question. Again, it has come. Mr. X is a director of ABC Private Limited. His suggestion date is 22nd October 19. Mr. X is also appointed independent director in March 21 in another listed company. in which another director of that ABC Limited is also director. Whether X of ABC is eligible to be independent for XYZ listed only. So a private limited company, 2 director is there. They both are director in one listed company. Whether of which one director is appointed as a independent director, whether he can be independent director in listed company.
I think he cannot be appointed because
Hello.
yeah,
Am I audible? Am I audible, sir?
yeah, Mr. Dilip.
Yes, sir. Sir, the question is same. I read the LODR. There is one amendment on 1st of January 2022. It says कि कोई भी जो मैनेजिंग डायरेक्टर है उसकी कोई रिलेटेड कंपनी में ही इज अ डायरेक्टर in last 3 years, then he is not able to appoint as an independent director. I think it is related to director and promoter. So I don't think this is, I mean, eligible to be independent, sir. I just want your view, sir. Actually, I read the LODI. It says that last 3 years, if he is a director related to promoter group company, then he is not eligible to be an ID in another listed company. So I just want your review
Your
so
your
that I.
your observation is very correct. In case of a listed entity, he cannot be an independent director, but if he is required to be appointed as an independent director in an unlisted entity, as per the requirement of the Companies Act, he can be appointed.
Hello, clear? Mr. Dilip? I think yes. Mr. Dilip?
He
Yes,
is
muted
muted.
himself.
He is in mute.
Dipti madam, can I leave? Can I take leave from all the?
Yes, Mr. Sanjay, thanks a lot. Mr. Sanjay has pre-occupation, pre-decided meeting, so he has some urgent meeting to attend. Thanks a lot, Sanjay bhai. Lots.
Thank you. I loved this interaction with all the team members, and thank you very much to specifically Dipti and Umesh bhai and Bala sir and Sailesh ji for also giving us good guidance on all this matter. Thank you.
Thanks, Sanjay. Have a good day.
Bye, bye, Sanjay. Bye.
Take care.
Bye, Umesh bhai.
Yeah. Bye. See you.
If you can free early, please join it again. Okay, then shall we, because others question, I typically took this fast because Sanjay was leaving, so I said better 1 or 2 discuss with him. We will take all the questions.
Dipti Ben, only 1 minute. I would like for all the participants to take note of it, that if there is any gray area, we should not do that thing. If there is, whether it can be done, it can't be done, whether what is the view of the other person, because today what happens is that those who are caught are thieves, those who are not caught are saukars. So it is always basically a good practice to be on the right side of the law, have a conservative approach into advising the clients or the corporates in which we are employed, so that you never cross the fault line. Because today the directors, see, according to my experience says, Balasab will agree, he has more experience than me. If it happens good, it was your duty. But if it bounce backs or if it backslashes, then you are gone. So it is always better to have a conservative view in complying the law, and we should see the spirit of law. That if the LODR says that if a director was a director, co-director into with the person who is CMD into a listed entity, it is always better not to appoint him and have a conservative view. For the purpose of Companies Act, he may be taken as an independent director, as said by Sanjay Bhai, but it is always better for us, because into the recent order passed by Registrar of Companies Gujarat into Tattva Chintan matter, there were many company secretaries, KMP, who would have changed. There were many people, but those who have applied have been penalized for 20 lakhs. And we don't know whether we are into that company after 5 years, 3 years or not. And if the notice comes to us, nobody is going to pay the penalty or fine on our behalf, since we have left the company and we would to shell out the money from our pockets. So it is always better to we become conservative and not to indulge into any activities which is very, very courageous. This is my own personal view.
Agree with you. And Sumit, you can continue other questions. Now today we will take at the end because it's mixture, it's not relevant to the topic. So we'll take it at the end. But we'll surely
Yeah, yeah.
take on. Yeah.
Okay, ma'am.
Yeah, Sumit, carry on.
Moving to the next slide. It's about the rights of the directors. As we discussed in previous slide, that section 179 talks about the powers of the board. Unlike, there is no such provision as rights of the board of directors of the Companies Act. But yet, by bare reading of the act, one can get the rights of the board. It can be classified into two types, that is individual rights and collective rights. So individual rights are those rights which are affected by individual, and the collective rights are the right collectively exercised by the board. So the individual rights of the directors are as follows. A right to receive the agenda from the board prior to the board or general meeting of the company. Right to attend the board meeting. Right to elect the chairman in the board meeting. If any resolution is supposed to be filed by circular, then the director shall have right to receive the draft of such resolution. Also, the director also have right to receive the minutes of the company. If the director wants to know any information about any transaction or any act of the board, then the director also have right to ask for such information regarding such transaction or the business of the company. These were the individual rights of the board. The next is collective rights of the director. So the collective
Sumit,
rights
your
right.
voice is not clear. Sumit, your voice is
Hello.
not clear.
Hello, am I audible right now, ma'am?
Yeah.
So
Little
collective.
bit, not yet.
Hello.
And keep your voice low and soft and
Okay.
keep mic little away.
So
Yeah.
collective right is a right which can be exercised by the director.
And go slow in speaking. Thanks.
Like appointment of managing director. So the board can collectively appoint a director by passing the resolution. Also, the director can collectively refuse to transfer the shares in a private company. These were the rights of the company, of the directors. Moving forward to the next slide is about the duties of the directors. So the duty of the directors are mentioned in section 166 of the Companies Act 2013. The duties are as like the directors need to act in accordance with the articles of the company. So the articles are the chartered document of the company, like MOA and AOA are the main documents of the company. So the directors need to abide by the articles of the company. So the next duty is like directors shall not have indirect or direct interest or conflict with the interest of the company. Like directors should not have derived from any interest of the company. Moving forward to the third is exercise his duty in due reasonable care and skills and diligence. The director also should act and promote in good faith for the object of the company and for the benefits of the members of the company. Moving forward to the next slide is about the director should not achieve or gain any undue advantage from the act which he does, which will fill his pockets. So also the director cannot assign his office, like we all discussed regarding the exception in this case is regarding alternate director. So in all other cases, the director is not eligible to be assigned his office, as the director is appointed by taking into consideration the expertise in the field for the same. So by assigning the office of the director, it will destroy the purpose of appointing a director. So if the director contravenes the provisions regarding the duties, then he shall be liable for fine of 1 lakh rupees, which may extend to 5 lakh rupees. Next is responsibilities and liabilities of the board of directors. So the liabilities can be classified in 4 types. That is liability towards the company, liability towards the third party, liability for breach of statutory duties, and liability for act of the company of the co-directors. So by bare reading of the heading, we all are aware what the liability of the director has. So like the first director, if the director breaches his fiduciary duties, which is entrusted with, then the director is liable for not complying with such duties, and the loss arising out of such act will be held liable for the director. Like the same, if the director act ultra vires or neglects any act or acted malefied, which resulted in undue profits, then then in such cases the director is held liable. So this is where the director can be held liable. Moving forward to the next topic is composition of the board of directors. So this is the composition as per the Companies Act. In public company, there need to be at least 3 directors, and maximum directors can be 15 directors. In private company, there should be minimum 2 directors. However, the maximum director can be 15 directors. In case of one-person company, if the company has only one director, then it is okay, and the maximum director can be 15 directors. Also, if the board wants to appoint more than 15 directors, then for the same, the board need to pass special resolution. This was the composition with respect to Companies Act. Moving forward, composition of board as per the SEBI. In case of SEBI, the board shall have optimum composition of executive directors and non-executive directors. In case of SEBI, the board should have minimum one woman director, and not less than 50% of the board shall comprise of non-executive directors. Board of directors of top 500 listed company shall have at least one independent woman directors. So this criteria is regarding the company should have at least one woman director. Also, if the chairperson of the board is non-executive director, then at least 1/3 of the board shall comprise of independent director. And where entity does not have regular non-executive chairperson, at least half of the board shall comprise of independent director. The composition has been discussed previously. The minimum composition of the board was 1 in case of one-person company and minimum 3 in case of public company. Unlike, the board shall have comprised of at least 6 directors if the company is listed company. So as we all discussed about the composition of the board, so now let's take a case study for the same. So in this case, ABC Limited is an unlisted public company. The paid-up share capital of the company is 10 crores and the turnover is 300 crores. And the current board of directors are comprising of 1 nominee director, 5 non-executive directors, 2 non-resident directors, and 1 managing director. So is this composition of directors valid? What are your views on the same? Hello.
I think Sumit, you only answer because we can't ask the audience. It will be too much thing.
Okay, sure. Okay. So in this case, we can see that the paid-up share capital of the company is 10 crores and the turnover is 10 crores. Though in case of public company having turnover more than 300 crores, it need to be at least 1 woman director. So in this case, woman director is not appointed. So board of directors should have woman director. Also, the paid-up share capital of the company is 10 crores or more, and at least 1 independent director needs to be appointed. So that will be a perfect composition of the board of directors. So that was from my end, and from here onward, Ms. Khushi will carry on for the same. So over to you, Ms. Khushi. Thank you.
Thank you so much.
Kushi, you're on mute. Kushi, you're on mute. We are not able to hear.
Sorry, sir. So we'll start with the different type of committees. Under the Companies Act, we have 4 mandatory committees, which is the Audit Committee, Nomination and Remuneration Committee, Stakeholders Relationship Committee, and the Corporate Social Responsibility Committee. Apart from that, as per the SEBI LODR regulations, we also have 2 other mandatory committees, which is the Risk Management Committee and the Whittle Mechanism Committee. We'll learn about these committees in detail further. As per the Audit Committee under the Companies Act, it will be applicable to the listed companies as well as public companies with a paid.
Go slow, please.
Sorry.
Slow. Keep the pace slow.
Oh, yes, ma'am. So audit committees will be applicable to listed companies as well as public companies which have a paid up share capital of at least 10 crores, turnover of rupees 100 crores or more, and who have an outstanding loan of at least rupees 50 crores. Now we'll see the composition of such audit committees. There have to be at least 3 directors, and a majority of such directors will be independent directors. That is as per the Companies Act 2013. But if we see as per the SEBI LOTR regulations 2015, the chairman, there's an additional composition criteria, which is that the chairman shall be an independent director. There's also a special note that as per the SEBI LOTR regulations, 2/3 of the members of the audit committee shall be independent directors. So we can see the difference that Companies Act states that the majority shall be independent directors, but as per SEBI LOTR regulations, it is 2/3 shall be independent directors. Moving on to the role of the audit committee. Their role is to oversight the financial reporting process, which is that, to oversight the financial reporting process, to recommend for the appointment, remuneration, and terms of appointment of the auditors. They will help in the appointment and the how to pay remuneration and the terms of appointment of the auditors, to approve the payment to the statutory auditors, to review and monitor the independence of the auditors, and should the company appoint such auditors, to evaluate the internal financial controls of the company, and to evaluate the undertakings of the assets of the company. Moving on to the next committee, the Nomination and Remuneration Committee. It will be applicable to every listed company and every other public company which has a paid up share capital of rupees 10 crore or more, which has a turnover of at least 100 crore or more, and which has outstanding loans or debentures exceeding rupees 50 crore or more. Now, looking at the composition of such committee shall at least have 3 or more non-executive directors, out of which at least 50% shall be independent directors. Now, the chairperson of such company may be appointed as a member of the committee, but it is not necessary that the chairperson of the company shall be the chairperson of this committee. Now, looking at as per the SEBI LOTR regulations, the Nomination and Remuneration Committee shall include at least 2/3 independent directors. The role of Nomination and Remuneration Committee is to formulate policies and lay down criteria to determine the qualifications and on what basis to hire independent directors, and to check if about their independence, to recommend to the board a policy relating to the remuneration of the directors, the key managerial person, and as well as other employees of the company, to devise a policy on the diversity of the board, on how to have different types of directors, and to make sure that all the criteria of the directors which is applicable are met by the company, to formulate the criteria for evaluation of performance of independent directors and the board. Moving on to the next committee, which is the Corporate Social Responsibility Committee, as per the Companies Act. Now, every company which has a turnover of rupees 1,000 crore or more, or net worth of rupees 500 crore or more, and net profit of rupees 5 crore or more, is liable to form a Corporate Social Responsibility Committee. Every company which has a Corporate Social Responsibility Committee, so like different types of companies, whereas there's a listed company, so such committee shall consist of 3 or more directors, out of which at least 1 director should be an independent director. Then public company and private company shall have 3 or more directors, but it is not necessary for unlisted public company to have independent directors. And if such companies do not have the minimum criteria of appointing only 2 directors, then both those directors should be the part of such committee. And as per the foreign company, there shall be 2 or more persons, or one shall be nominated by the foreign company, and one director has to be a resident director. The role of Corporate Social Responsibility Committee is to formulate policies and recommend to the board the CSR, the Corporate Social Responsibility Policy, to tell the board, to advise to the board the activities which can be undertaken by the company, and to also recommend and advise the company the amount of expenditure to be incurred on such activities. The committee also has responsibility to monitor the corporate social responsibility policy of the company from time to time.
Looking at these new amendments happening in CSR and all that, this committee is becoming more and more crucial, and their role is becoming really difficult and vast. Right, Mr. Bala? It's like that way.
Yeah, that is true, because CSR is actually taking a very, very big leap now. In fact, it will be in the past, one of the seminar also, we did discuss actually this. The CSR is really, really going to be a crucial things for the companies who has to ensure that the compliances will be required, and day by day they are actually tightening the thing, because not only that, it is always working towards the upliftment of the society and giving back to the society from the company. That is the way we are moving on this.
Yeah, Miss Simanti, you have raised the hand. Simantini, sorry.
Yes. I have one addition to make and one question. For private companies, if the CSR liability is 50 lakhs or more, then only the committee needs to be formed, or the duties can be fulfilled by the board itself. This was recent change which had come last year.
That is right. This is a recent change which has come in the amendment. You're right.
Yes. So section what is shown is true, because I remember this because I dissolved the CSR committee in my organization. Second thing, my question towards, may I ask the question? It is more towards CSR, or let the presentation end?
Please ask.
My question is, suppose a company is into, say there is scarcity of funds, okay? There are cash flow issues or cash crunch. There is a profitability, okay? But there is a cash crunch, genuine cash crunch. How the company is expected to fulfill the CSR responsibility, whether it should be at the cost of holding back increments of employees or supplier payments? Because I read the section, I checked everything. If profitability is there, liability is applicable. If you don't spend 6 months time given, whatever, transfer the funds to that Prime Minister Relief Fund and Ganga, those funds, or you can shift it to ongoing projects and then use separate bank account and all that. But as such, because profitability is different and cash flow or your cash position is different. So any view from experts how to handle such kind of situation?
It is not your own issue. It is an issue with various companies across the board. Now,
I would ask us, sorry.
Suddenly, earlier it was only.
Yeah,
carry on.
I would ask a similar question of Simantini. What would you do with TDS? You don't have money to put TDS. What will you do? You have paid salaries. 1 minute. You have paid salaries 100 rupees and the TDS is 10 rupees. You paid 90 rupees, but you don't have 10 rupees to pay to the government. What will you do? Risk prosecution, jail. Similarly, in this case, borrow the money and do it.
Umesh bhai, you are telling something?
Exactly.
Is borrowing. Sir, my question here is for the TDS. I think when you any company is paying 100 rupees salary, so the fund is already available, right?
Not necessarily.
And it is
No,
out
not
of
necessarily.
No, no.
Hello.
Simantri, yeah.
You may have 90
Yeah,
rupees.
Shailesh bhai.
Oh, okay.
Shailesh bhai, I was coming into that, but you have come straightway to the, you were rather blunt. I was trying to be diplomatic. So, see, these questions, Simantri, is applicable to all company across the board. Unlike what Shailesh bhai said that TDS is a current responsibility, what you are supposed to pay. Whereas CSR is such a thing that you have to take out the average profit and then expand it.
Correct.
Earlier in the act, there was a provision that this was required simply to be mentioned in the board and they were comfortable.
Correct.
But now there is a liability which is arising out of it. So it is always better to have a financial planning done.
Correct.
It is not that you can simply cut and not give the increment, or it is not that you don't pay to the suppliers. It is something like a supplier only. Government is trying to become a partner into the business, and you have to give their share first and then have a cake. I was just reading some WhatsApp message couple of days back that you should rather train your children to share, because at times they should know what is TDS. So you should take bite first. Then you should ask him to give a piece to the mother so that he happens to know that the taxes are to be paid before the fruits are enjoyed. Similarly, like this, the corporates, it is a new thing. It will take time to stabilize, but corporates have to turn out their culture into such a fashion that the money is set aside first and then the new expenses are to be made. I am into this corporate world for almost 3 decades now. I have never seen a promoter becoming poor. I had in one of the programs, somebody said while there was BIFR that companies do become sick, but the promoters become more stronger. That is what is happening into CIRP also. So promoters have to change their mindset. The directors, they have to change their mindset and they have to set aside the money. This is what Shailesh bhai said in a single sentence, but I said in a lucid language so that it may convince you. Shailesh bhai, I am there with you 100%.
Thank you. I'm talking about this from personal experience. I was the director on board of a company which was to pay salaries but not deposit TDS. I promptly resigned from that company, but that sword of Damocles still hangs on my head because
They used to, sir, they used to leverage, they are used to leverage that amount of TDS for quite some time. कि TDS का पैसा कटा, उससे अभी supplier एक को शांत कर दो, TDS का 2 महीने बाद देखेंगे. That is how the promoters, but they have to change their.
Yes.
So, ma'am, you have to ask the promoters to change. This is a new India, and new India is very strict. You cannot have any sorts of bypass being made, and you have to abide by the law. That's it. Simple.
Simantri, it is like that earlier it was voluntary, now it is compulsory. Simple.
Mandatory. Yes. We are, no, my challenge didn't come from the management side. It was more from, when this fact got disclosed in the company, and if 1 year increments are held up, employees, it was very tough for the management to explain, that a company has funds to do the CSR, but don't have funds to pay increments. That became little challenging.
Yeah, everyone says this. All
It's
over
a
India
matter of
companies face
perception.
this situation.
So borrow, no? You're a profitable company. You will get borrowings.
Yeah.
Okay, this is a new
So
idea.
it's a simple
Got it,
line.
sir.
It's a compulsory.
Yeah. Thank you. Got my answer.
That way, you know, to actually introduce some incentive scheme to collect money where the money is not coming out, although you are showing a profit. It is basically a, you are making a profit. The profit is sitting with the money receivable, but the money is not coming into their bank. That is the problem. Correct?
That is the problem. Correct.
If that is the case, you know, to actually
Receivables
formulate
was
a
the problem.
policy to how to increase the collections in time. Some sort of the incentive, etc. scheme you have to do. and you have to increase your collection and see the cash coming into your kitty. Otherwise, see, the same thing can happen. You'll be unable to pay your supplier. You'll be unable to pay your employee. You'll be unable to pay other services also.
Yes.
Right. Okay, Khushi,
Good.
please
Thank you.
continue. Yeah.
Yes, ma'am. So now moving on to the next committee. It is the Stakeholders and Relationship Committee. Now, any company which has more than 1,000 shareholders or debenture holders or any other kind of securities, they shall form such company. Such companies will be formed to resolve the grievances of such security holders. The chairperson of such committee shall be a non-executive director. This committee shall comprise of at least 3 directors, of which at least 1 director shall be an independent director. And the committee shall meet at least once in a year. The role of a stakeholder relationship committee is to, the main aim of forming such committee is, of course, to resolve the grievances of such security holders. But also they have to ensure timely receipt of dividends by such shareholders and security holders, and make sure that they receive the annual reports or statutory notices, to review the various measures and initiatives which are taken for reducing the quantum of the unclaimed dividends, so that there is smooth functioning of the company, and to review measures taken for effective exercise of voting rights by shareholders. Now, role of Risk Management Committee. Risk Management Committee is a mandatory committee to be formed under the SEBI LODR regulations. The role of such committee is to ensure that appropriate measures are taken to achieve the prudent balance between risk and reward, to evaluate significant risk exposures and assess the management's actions to mitigate the exposures in a timely manner, to make regular reports and to keep the board updated about the risk and about how it is being managed and avoided, to review the performance of the Risk Management Committee annually. Moving on to the Vigil Mechanism Committee.
1 minute. Risk Management Committee is also required to be formed under the RBI regulations by the NPSC companies.
Correct.
And NPSC companies can be registered either the public company or the private company. Under the companies, private companies need not have many committees. But however, if the private company happen to be a NPSC company, under the RBI regulation, the Risk Management Committee will be required. And also a audit committee will be required.
Right, sir. So we have covered committees under the Banking Companies Act.
Okay. If it is there, it's good. Okay.
Yes, sir. So now moving on to the Vigil Mechanism Committee. Composition of committee. Every listed company is supposed to form a Vigil Mechanism Committee. The companies which accept deposits from the public, as well as the companies which have made borrowings from banks or public financial institutions exceeding rupees 50 crores. The role of Vigil Mechanism Committee is to provide for safeguard against the victimization of people who use such mechanism, to protect such people, and to make provision for access to the chairperson of the Audit Committee in special cases. This is just a diagrammatic representation where the shareholders elect the directors who delegate who give delegation to the committees and the officers for the day-to-day operations. Now we can just have an overview of committees to be formed by the insurance companies. There are many mandatory committees which an insurance company is supposed to form. First, looking at insurance companies are supposed to appoint minimum 3 independent directors on their board. But there's a relaxation on this, that 2 independent directors can be appointed for the initial first 5 years. Moving on to the audit committee of such insurance companies. The audit committee of insurance company is supposed to appoint minimum 3 directors, but majority of such directors shall be independent directors. An insurance company is also supposed to form an investment company, which shall have at least 2 non-executive directors, there shall be the chief executive officer or chief financial officer or a chief of investment, a part of such committee. Then there is risk management committee, which is also a mandatory committee. Such committees are formed for a strong mismanagement system and for mitigation of risk strategies. Then there's also policyholder committee, which is formed for adoption of sound policy and for healthy market practices in terms of sale, advertising, promotion, or publicity of such company. Then there is nomination and remuneration committee, which is also a mandatory committee. It is formed on the same lines as per section 178 of the Companies Act 2013. The Corporate Social Responsibility Committee shall be formed by an insurance company if the net profit of such company is more than or equal to rupees 5 crores during the immediately preceding financial year, and they are obligated to spend minimum 2% of an average of the preceding 3 years net profits. Then there is a with profits company, which is a voluntary committee to be formed. But this committee is formed for the profit fund management and the asset sharing. Then there are other committees like ethics committee, asset liability management committee for such insurance companies.
Just 1 minute. This ALM committee, Asset Liability Management Committee, is something which is peculiar in insurance companies, NBFCs, and banks. Simantani, for your company, I would strongly advise you to voluntarily have an ALM committee. It will take care of the problems that you're facing. Voluntarily have a committee, Asset Liability Management Committee.
Okay.
And who will be the members of this?
You just look at the requirements in the NBFC Act. It will be generally but it will help you overcome all these problems. They will be anticipated well in time.
Yes, thank you.
Thank you so much.
Thank you.
Moving on, for the committees for banking companies, have to form an audit committee. The majority of such committee shall be independent directors or as well as non-executive directors. And the executive director of such bank, one of these directors shall also be a member. Then there is a risk management committee. Again, it is on the similar lines as we discussed in the insurance company. There shall be a strong risk management committee for the role of such company to be further strengthened. And every banking company is required to form such committee. Then there is a nomination committee. It is formed for appointing independent and non-executive directors of banks. Such committees and such directors are hired and are appointed to scrutinize nominations received for independent and non-executive directors. Then there is supervisory committee. Supervisory committee shall be formed in all banks to monitor exposures for both credit and investment of banks, to review adequacy of the risk management process, and for to make better and to upgrade the internal control process of such company. And there is also shareholders redressal committee, which is for increase in the access of capital market. So if there's an increase in need for an effective machinery for the redressal of investor grievances. Moving on to the committees for non-banking financial companies. There are 3 important committees for such companies, which is audit committee, which shall have minimum 3 directors again, and which shall have the same powers and duties as Section 178 of the Companies Act 2013. There is risk management committee to manage the integrated risk of such non-banking financial companies. and the Nomination Committee to ensure fit and proper status of the existing directors as well as the directors which are supposed to be appointed in the near future.
Khushi, this should include ALM also, Asset Liability Management Committee. It is a compulsory committee for NBFCs.
Okay, so.
And it's a very, very useful committee.
I'm sorry, I missed out on that.
Yeah, that is what I said in the beginning there when you are talking about insurance company. Yeah.
Right, sir.
Okay, please go ahead.
Yes, sir. So now there are obligation of directors with respect to related party transaction. Directors shall beforehand disclose to the company any contracts or any arrangements which they have with the company, or if they are planning to acquire such. Failure to make such disclosure should be treated as a default. And if a director who has done such default shall be held liable, and she shall have vacated his office. Now, certain transactions in which directors are interested will only take place by if there is an approval given by the board or by the shareholders. And such directors who have an interest in the company shall avoid participating in the board meeting in which such topics for agenda items are to be discussed. Obligation of directors with respect to the takeover code. A director shall facilitate the acquirer in the verification of shares tendered in acceptance of the open offer. The director shall also make available to the acquirers who are making competing offers, if any information or anything which is to be provided to any acquirer who has made a competing offer, to ensure that the obligations on the target company are also adhered to ensure that during the offer period, the target company and its operations is conducted in the as the ordinary course of business and is consistent, and to register without any delay the transfer of the shares which are acquired by the acquirer. Now, directors with respect to price sensitive information, there shall be a code which shall be formulated for conduct with the approval of the directors to regulate and monitor the trading of such price sensitive information. A policy shall be formed for legitimate purpose as a part of the codes of affair and disclosure and conduct. The director shall maintain the price sensitive information in confidentiality, and they shall not pass on such information to any person, either directly or even indirectly. When the trading window is closed, the director shall not trade in the securities of the company. Now we'll see what the trading window is. The trading window is the period during which the purchase or sale of the securities can be carried out. The trading window shall be closed at least 7 days prior to the day when the unpublished price sensitive information will become public. The trading window shall also be closed from the end of the quarter till after 48 hours of the declaration of financial results. The directors and the people who have such price sensitive information shall not disclose such information even to their immediate relatives, and neither shall they trade when the trading window is closed. The financial statement shall be signed by either the chairperson of the company if he is authorized by the board of directors. It can also be signed by 2 directors, but it is necessary that one of them shall be a managing director. And either the chief executive officer or the company secretary or chief financial officer, if such officers are appointed in the company. But the chairperson of the company can sign financial statements after he is authorized by the board of directors, even if he was not the chairperson of the previous meeting, and such financial statements which are signed shall be submitted to the auditor, after which the auditor shall prepare an auditor's report. Now we are going to discuss some relevant case laws to get a clearer view about in relation to directors. The first case that we are discussing is about Shivkumar Jatia versus the state of NCT of Delhi, which is the National Capital Territory of Delhi. Now in this case, basically this case was a negligence. The blame was on part of negligence to the managing director, but the judgment was that even though there are allegations of negligence on part of the hotel and the officers who were in charge of the day-to-day affairs of the hotel, the managing director cannot be held liable and no allegation shall be made against him, as he was not, firstly because he was not present, secondly because he is not liable for the day-to-day affairs of the company. Moving on to the second case. This was the case of Director of Writer Safeguard Private Limited versus the Labor Enforcement Officer. In this case, the Supreme Court held that a person cannot be held liable because of his status or position as a director, manager, managing director, unless there was a consent of such person in such a case or in such a situation, without which no allegations shall be held against such directors or managers. Now further will be taken over by Sumit. Thank you.
In this particular case, what you have talked about it,
yes,
you know,
sir.
What happened, it was actually a hotel. In the hotel, there was a guest who was actually staying there. And he went actually in the terrace for smoking purposes or nothing. He had a fall and he died. A criminal offense has been actually made against the managing director and the manager of this particular company. And they actually lodged a criminal complaint. So criminal complaint has been actually caused by the Supreme Court in this case, because they said when you allege the criminal complaint, there has got to be an intention and the party to it is there. That was the question which actually came here. Because number one, they were not at all aware. Number two, they were not party to it because the guest happened to happen. But only thing is which arose is that hotel should have taken the necessary safeguard to providing the separate smoking area, etc., developing and safety measures. That is a separate issue which will come up. But the criminal complaint which has been lodged against the people has been actually quashed. That is the case.
See, as a part of risk management program, we can also suggest and considered by the many companies. It is called a director's legal liability policy to mitigate the risk of the directors in terms of the financial liability and legal liability, so that there is any proceeding cost and all, lawyers cost, those things can be indemnified by the underwriters or insurance companies.
Sorry, you are making comment or you are asking question?
This is just because of this type of, sometimes this kind of litigations are happening against the directors because of they are on the board. So we can take this kind of policy or some insurance program to cover the risk of the directors.
Right.
That's the only point.
Yeah, okay, thank you. Yeah.
Hello.
Carry on. Yeah, please.
So moving on to the next case regarding Karan Gupta and Union of India. So in this case, Karan Gupta was director in a company and he resigned from the company for the post of director.
Sorry, there's echo in your thing, please.
I'm audible now, ma'am?
Yeah.
Okay. So Karan Gupta was director in a company. So the director, after post, he filed a resignation in that company and resigned from the post of director. Post which the company failed to file financials and audit report with MCM. Pursuant to which all the directors of the company all of the company disqualified from the post of directors. So in this case, if when the Karan Gupta was also director, because company has not filed DR12 for resignation, and in this case, the Karan Gupta was also disqualified from the post of director. So in this case, Delhi High Court stated that while the Karan Gupta the negligence was one of the part of the company, and because of the same, the Karan Gupta will not be disqualified from the position of directors. So this was the crux of the case. Moving on to the next slide regarding.
So basically, for failure on the part of company to comply with, the director should not be penalized. That is
Yes,
the.
yes, ma'am.
Okay, carry on.
So next part is regarding Rajesh Kumar. Rajesh Kumar Yaduvanshi was a serious fraud investigation officer. So in this case, the Rajesh Kumar Yaduvanshi was nominated director. So there was material allegation difference in the in SFI report. The direct companies claimed that there was a negligence from the part of the directors, nominated director also. But in the investigation report submitted by the SFIO, there was no negligence from the part of the from the nominated director. And in this case, there was no material difference between allegations that nominated director has been neglected and the allegation that he has complete involved in approving the financial statement, which was false. In this case, the financials were false. So since there was nothing against the nominated director in the investigation report, he cannot be held liable for the negligence, but can be prosecuted for fraud. Accordingly, the summon was issued for the same. So moving on to the next case regarding Opal Devendra Kumar versus Security Exchange Board of India. So in this case, the company was there was a transaction with the two companies. In this case, the contention of the SEBI was that being a director of the company, the appellant cannot disown his responsibility for the act of the company. In this case, Security Appellate Tribunal held that appellant was director of the company. However, a finding has been arrived that the appellant was responsible for the day-to-day affairs of the company and was involved in the collection of monies and implementation of the scheme. It is not necessary that every director is required to be penalized merely because he was a director on the grounds that he was deemed to be responsible for the affairs of the company. So if the director can be explained that there was no role that he played for the alleged default, so he was not, so it will turn out not responsible for the affairs of the company. In this case, the director was not penalized for the same.
Bala, what about that provision these days that if it is proved from the records of the company that he is aware of the proceedings, how will that fit this? You know that new thing which has come in, that he is deemed to be aware on the basis of minutes, etc. That he was present and he got the agenda, he was present at meetings. That will hit him, no?
I think
Bala, you're on mute. Bala, you're on mute.
Yeah, if he is actually keeping quiet and silent spectator, you are very much right. But if he is actually not party to the things and he has not, raised any desistance against that, that can safeguard him.
But not party, but aware.
Yeah, but if he says that he objects, he shows his objection and say that it should not be done, then what he can do in the minority? So
No. He does nothing. He just sits in the meeting.
Then he will be responsible.
Yeah, if he sits in the meeting, he is responsible.
He sits, all right. He is not in the meeting, but he receives agenda papers and minutes. All right, let's take it that way. Yeah. He receives agenda papers and minutes. And he does nothing.
Silas Bhai, it is again on a factual thing. In minutes, what is noted, what is decided, if that reveals which is, he understand that not correct and he should raise the question and he doesn't raise.
So it has gone a little bit beyond actually being aware, participating. Being aware, even indirectly, can put you in trouble.
Yes.
Yeah, that is right. You're right. Absolutely, you're right. But the only thing is, as you rightly said, by receiving the agenda on the document, whether he is really aware or not, that is a question will come up.
So it is factual also, factual.
Yeah, okay.
Yeah, next.
So next case was regarding SEBI versus Boolean Energy India Limited. So in this case, the takeover code was applicable. So the respondent argued that they cannot appoint a director on target company during the offer period as per regulation 22 subsection 7. As per the regulation, offer period has been defined to be period starting from the date of entering into memorandum of understanding, and in this case, no memorandum of understanding was executed. So the offer period should commence from the date of public announcement, and the director was appointed before the date of public announcement. So there was a gross violation from the same. So Supreme Court held that if the no MOU was entered, the offer period will start from the date of share purchase agreement and not from the date of public announcement to serve the object of the regulation. Accordingly, Supreme Court held that order of the SAT to be set aside and the adjudication of the order of the SEBI should be restored. Moving on to the further case regarding Alibaba. So in this case, Alibaba was a director of the company, and the company issued certain checks to respondent, and the checks were dishonored, and hence the respondent was filed for the case against Alibaba. In this case, he was resigned 8 years prior to the issuance of the check, and the resignation was duly filed with the ROC. So the director will not be liable for the disqualification for the checks which were dishonored, because the resignation was also filed by the MCA. Moving on to the next slide regarding CAD Software India Private Limited versus KK Jagdish. So KK Jagdish was removed as a director of the apparent company pursuant to the management from the loss of confidence. KK Limited was the managing director. So KK Limited argued that he should be eligible for the compensation for the law of rupees 1.105 lakh rupees along with the interest for the delayed payment. So the company argued that due to the loss of confidence, we cannot give you payment for the loss of the confidence for the compensation. So in this
what happens quite often in this loss of confidence business is that though it may not be in the act, I don't know whether it's there now, but in the past it was not there, of course, it is very often there in his contract. In the contract, he says that you may be removed if there is loss of confidence. I don't know how the two will go, Bala.
Okay.
No, I don't know whether he would still not get.
What happened in this case you're discussing?
So in this case, it was like management was KK Limited was eligible for the loss of the confidence for the compensation.
Yeah, but if the agreement between the company and the managing director had a clause that in case he is asked to go because to step down because of loss of confidence of the board, it's there in the contract. I think that may prevail, no?
Yeah, if it is contract, it will prevail, because normally most of the company, they actually enter into the agreement. There is a separate clause is actually there.
Yeah, it's there. Such a clause is usually there.
Yeah, the severance compensation or compensation for loss of office, that is there actually. If the contract entered between the two parties, then as you rightly said, that will prevail.
Yeah.
Yes, sir.
In this case, there might not have been such a contract. Huh?
Yeah.
It's quite possible.
That is correct.
That might be the reason KK was eligible for the compensation.
Yeah.
So that's it from our end. So from this, we end our presentation. So thank you everyone for the participation and for the panelists also.
Thank you. Very nice presentation. Very nice.
Thank you, both of you. Now we will take the question. Panel, get ready. Umesh bhai.
Kushi and Sumit, you have all done excellently a good job on compiling the various case laws, etc., and all these things. And you have covered almost all the topic. Good job done. My appreciation to you.
Yes, sir.
Okay. Okay, let's take the question. And first I'll take last week question. 2, 3, 4 remained only. One is from CS Urvi. Can a private company have only nominee directors? I have seen one company. What should we do in this case? So one private company has only nominee directors.
It can be, Diptiben. I don't foresee any issue that there has to be a promoter director.
Yeah.
But basically, they are not the nominee director, then they would be the professional directors. See, Larsen and Toubro, there is no promoters. There are many companies. Even in ITC, in the earlier days, there were no the promoter was only that British Tobacco Company and there was no other promoter. In India, there are many listed companies who are not having the promoters, but then they would be treated as a professional director and not the nominee directors.
Okay, next question from Jai Goyal. There are 3 directors in the company, private limited, out of which 1 director is not attending the meeting and have no communication with the company. How can we close the company without his consent and documentation? His shareholding is 33%. Can I repeat?
No, I have question number 29 as was circulated.
Yeah.
Balasab, would you like to answer?
No, you please go ahead.
Sir, I would request he first has to be removed as a director, remove him as a director, and then move ahead with closing down of the company. It is only a ordinary resolution for removal. He is removed and then close down the removing him as a director. Simple.
Okay.
Balasab, any different view?
No, this is correct. This is a practical view.
Well, my side, sir, it would be more practical. I am not an academician, sir.
See,
Okay.
Yeah.
we should always interpret the law within the framework of the law to the interest of the company. Practically, what is possible.
Yeah. Next question. Can a person play dual role of company secretary and director in the same company? So
There are many company secretaries
Of course,
who are
in fact, there are
directors.
many companies who say
Why
be a director
not?
and the company secretary.
Okay. Now we are coming to this today's session checkbox only.
I think Hindustan Lever, no, Balasab he had
Hello.
Some problem is there in the voice.
Adipti Ben.
We were not able to hear. There was,
Some problem was there.
last your comments we were not able to hear last 1 or 2 sentences. No, again there is a problem, Ms. Bay.
Some echo is coming.
Hello. Okay, Mr. Mala, shall we take next question? That is of now current chat box we started. How, Ms. Bay? Sorry. You are on mute. You are on mute.
મને તો કાઢી મૂક્યો તો મીટિંગ માંથી.
Some problem is there. We are not able to hear you.
Who was?
Umesh Bhai, there is some audio.
My mic is mute. Let me disconnect and I will come back again.
Yeah, we are starting the question meanwhile. Okay. Mr. Bala, the next question we are taking is, board of a private company passed a resolution for issue of shares to an outsider, which was originally issued to the existing shareholders. So basically question is, in private company, they have offered the shares to existing shareholder. Some shareholders who has declined that offer. So the board issued the same to other people who are not shareholder. So whether it will be considered still as a right issue? That is the question. I'll request Mr. Bala to you. Umesh Bhai, you can speak. No, I think there is an issue.
I think still there is a problem. Or he is in. Now he is unmuted. No, again mute.
Yeah. Tell me.
Yeah, so in a private company, there was an issue, and whereby the shares were offered the existing shareholders. Some shareholders decline, and then the board has offered that shares to outsider. So the question is whether it is a right issue. Still.
No, provided that resolution contains a clause saying that the shareholders may renounce the shares, but once again, that transferability of the shares into a private limited company, say adding the new members, etc., has to be checked up. Unless there is a resolution, enabling resolution that the shareholders have a right to renounce the shares, it cannot be said a
right issue.
Then it would become a private placement.
Right, perfect. Okay.
Balasab, your view?
Yeah, absolutely, you're right. It cannot be. It cannot be a right issue, but the only thing is, being a private company, the restrictive clauses of the share issue to the other party, that has to be checked.
Okay. Next question. If there are two directors in private limited company and they are only the shareholders of the company, now one of them passed away, what can be done to comply provisions of minimum two directors and how the shares transfer should happen? Again, the similar question. Two directors, they are in jail. How to do that? Umesh bhai.
આવા બધા સવાલ તમે ઉમેશભાઈને જ પૂછો છો.
In case of
sorry, Mr. Rathi is not there, so you are left over, and then I will of course request Mr.
No. In case of two directors,
It is. Yeah, Bala sir.
In case of the two director, one director passes away, another director is there. The law says actually the director can actually call a board meeting only for the purpose of inducting an additional director.
Right.
So he will have to call a board meeting and he has to induct another director. That's all, close a meeting. Then again conduct the affairs.
And sir, the person who are in jails,
yeah,
the remaining shareholders, if there are any shareholders, they may call a requisition meeting and appoint.
There are only two shareholders.
Both director, both shareholder.
Yeah.
Both are in jail. How to?
They may issue a notice from jail, signing saying that, say, Diptiban, last time also I said that the meeting with advocates, is allowed in jail. So they may sign it. If the nomination into, say, the parliament elections are being filed from jail, why can't a requisition be called from a jail? The shareholders may call a general meeting and they may appoint some other two directors to take it over forward.
Right. Okay. Next question. Can I appoint a person as an independent director if the person works for an FII who are holding more than 10% of the company? So if a company has foreign institutional investor with 10% holding, whether employee of the said company can be appointed as independent director? That is the question.
No, he cannot be an independent director.
Right. He's an employee and that also holden. Okay. Next. Umesh bhai, any comment? Separate?
No.
Okay. Okay. Now the question is, board of a private company issued CCDs under section 62, which will get converted into redeemable preference shares subject to approval of shareholders. Section 71 states that company may issue debentures with an option to convert such debenture into shares. Rule says that shares or securities means that such shares or securities shall be convertible into equity shares. Which section will prevail over the other? First is section 62, which says that CCD under 62 will get converted into redeemable preference shares subject to approval of shareholder. 71 states that company may issue debentures with an option to convert such debenture. Section 62 says that shares or securities, and 71 says debentures. Which section
Securities, we have to see. 62 see 71 is I think it is speaks about pure measure, speak about the convertibility of the same. Next,
Some problem in the voice again.
Again the problem is.
Yeah.
but as a you please carry on.
Mr. Bala, you have to take it up, this question.
Let me see. Let me look at the question.
Who is the questioner? Mr. Shiv Kumar, can you unmute and raise the question?
Hello, am I audible?
Yeah.
Yeah.
Now, there is a company which has issued CCDs and which says that it will be converted into a redeemable preference shares. Now, there is a confusion between section 71 and section 62. Section 71 says that debentures can have an option to convert into shares. Now, shares includes preference shares also. But section 62 says that there is an explanation of shares and securities, which says that it should be convertible into equity shares, ultimately into equity shares. So there is a confusion between these two sections, which will prevail. Whether is that CCDs, can it be converted into a redeemable preference share? That is the question.
Okay, so question is, you are saying that whether it will be convertible in the redeemable preference share or it will be convertible in the equity share.
Because we are saying it is a debenture, it's a CCD, which we have passed under section 71. 71 says that it's an option to convert into shares. Now, shares includes both equity and preference both.
Yeah.
But
And
62,
you have not clarified at the time of issue of debentures, it will be which shares?
no, that we have already said. We have said in the terms of issue that this will be converted into a redeemable preference shares.
Right. And 62 clearly says it's equity shares, right?
There is an explanation to rule 13, which talks about shares or securities, which they have explained that this will be ultimately converted into an equity.
So then in that case,
it will prevail only equity share. It will not be a redeemable preference share.
Okay, then on 62 will prevail over 70.
Yeah, that is right.
Okay, sir. Okay. Thank you so much. Thank you.
Sorry. The board next is the board approved a CSR policy which stated that committee will seek approval from the board on CSR expenditure only if the CSR budget exceeds the threshold stipulated by the act. Is it right approach by the board? The board approved CSR policy. The CSR budget exceeds the threshold.
Hello.
Hello.
Can I intervene?
Yeah.
Now, the objective of this policy was, in any case, the board has to approve 2%.
Yeah.
Okay. So if the policy itself says that this power is given to the committee where it exceeds 2%, then you come to me. Otherwise, you don't come to me. Is it tenable? Is it all right?
I don't think it will be all right, because CSR committee is a committee which actually recommends the expenditure to the board and the ultimate approval is given by the board.
Yeah, but the threshold in any case, nobody can breach.
Yeah.
Okay, so then what the company proposes to do is it will put it in the policy itself, and that will be approved by the board. So it's in turn, it is approval of the board only.
So that means what you are saying is the policy is approved by the board, spending of up to 2%.
Yes.
Which will be decided by the committee.
Yes.
So that means board is already given a what you call free approval.
Yes.
That is what you are saying.
Yes, sir. Yes.
Yeah, that can be done.
Okay. That is the right approach.
Yeah.
There is no default.
Yeah, that can be done.
Okay, okay.
Umesh
Thank you,
bhai,
sir.
you want to say something or if your mic is on now?
He is in mute.
Nothing.
Oh, okay, fine. Now we have a last question. In a listed company, total number of directors is 7. 3 directors are independent, 2 are MD. None liable to retire by rotation. Is above composition fulfill criteria of section 152(6)? In listed company, there are 7 directors.
3 are independent.
Yeah, 3 are independent. 2 MD are there, not liable to retire by rotation.
2 are executive. And 2 are the people who shall be retiring by rotation.
Right. But here it is not liable to retire by rotation.
नहीं पर 3 independent.
Yeah, 3 independent.
Rotation. 3.
Umesh bhai, not audible. Mr. Bala, Umesh bhai.
Umesh, you are on mute.
We are not. Mr. Bala, I think you can have to answer so that we can now close it.
Yeah. So here the question is, the listed company is having a 7 directors. Out of that, 3 directors are independent directors. 2 are actually MD, non-liable to retire by rotation.
Right.
Is the composition is full. First of all, there is something wrong. What is the, unless we have the share capital, etc.
Turnover, profit, all that is also required.
What happened to the woman director?
That's why turnover, profit, share capital, everything is required.
Yeah, because the question will come of the woman director. Question will also come about this independent director, and they are talking about the MD. So, and again, the chairman and managing director is who? Is a combined position or different position? That will play the importance to know the composition of the board.
Yeah. Okay, I think it's a factually incomplete question. We have concluded all the questions. If anything left out, they can very well write to us. Meanwhile, I thank Umesh bhai and of course Sanjay, who is not there now, he left in between. Our own Mr. Bala for all the wonderful session. And of course, Shailesh bhai for interesting googly questions. And thanks all for everything and your participation. Have a good holiday. Thank you.
Thanks a lot to everybody.
Thank you, Dipti Ben. We enjoyed 2 Saturdays. My team also is there with me who has participated. So you can count 6 more participants who had attended along with me.
Oh, great.
So,
great.
Thank you very much. This is the team available.
Oh,
they are
great.
here.
So we should ask more questions.
No, but they also enjoyed these 2 Saturdays and we are happy that it is more fruitful. And we look forward for more such programs from Mehta and Mehta where we can attend. And we shall attend even as a participants. So all the best to the team and the people behind who have prepared the presentation. They also be given kudos and great efforts by them. Thank you, Dipti Ben.
Thank you. Thanks a lot.
Thanks a lot to everybody. At least
Balaji,
this presentation brought to see Umesh after a long time.
Yeah.
Sir, my pleasure, sir. This is the new era now which is starting. Instead of meeting at seminar and conference, this is the only media what has been left out, sir.
Correct. You're right.
Thanks,
Yes, sir.
everyone. Thanks, everyone.
Okay, Dipti Ben.
Thanks,
Balaji, good day.
Bye.
Have a good time. Take care of your health, which is the important order of the day.
Thank you.
Thank you.
Yeah. Thank you, sir. Thank you.